Hello, everyone.
Hello.
Hi.
Hello, everyone. This is thank you very much for participating in the joint webinar of Lexist and King&Spalding. I'm Murat Erbilen. I'm a partner at Lexist. I will be moderating the webinar today. I have three esteemed colleagues with me today. Tom Spranch, QC. Tom is the managing partner of King&Spalding London office. He's joining us from London today. Thank you, Tom. He represents clients, states, investors, commercial clients, working in a very broad range of practice. He's a graduate of University of Sydney, and he holds a master's degree from the University of South Wales. Our second speaker today is Viren Mascarenhas. Viren is joining us from New York today. He's a partner at King&Spalding New York office, also a member of international firm's International Arbitration Practice Group. Viren is a graduate of Columbia Law School, where he also teaches a class as co-lecturer, as far as I know, still. He represents clients in a very broad range of matters, acts for states, investors, other commercial clients. Our third speaker today is Turgut Aycan Özcan. Aycan is the head of arbitration practice of Lexist. He represents clients, states, and investors, and commercial clients as well. He's a graduate of Bahçeşehir University. I'd like to start with Tom. Tom, in the midst of this pandemic, virtual hearings became a very hot topic. What did we learn from experience as to virtual hearings?
Hi, Murat. Thank you very much for having us today. It's a pleasure to be with you all. And it's no coincidence that rather than being in a nice conference room somewhere in Istanbul, we're all on video. And I agree with you. Virtual hearings has become a very hot topic since the crisis. And the simple reason for that is for the wheels of justice to continue to turn. The only way it can now be done in most instances is virtually. So that's why it's become such a hot topic. I've got a set of slides that I'm going to step into in a moment. And what I would emphasize before the slides come up and before we get into them, please don't regard me in any shape or form as an expert in virtual hearings, because until about 8 or 9 weeks ago, my virtual hearing experience was limited to the odd case every now and again, whereby we'd all be in a hearing room, and what would happen is that 1 or 2 witnesses might not be able to attend, and we would then have them joined by video, and all of the participants, the court or the tribunal, and all the lawyers would look up at a screen, and the witness would be there. A lot of people, and myself included, felt that because we'd had that experience, it meant that we would know how to do a virtual hearing. But as I'm going to show you with the slides and various other things, that's not the case at all. And there is in fact a huge difference between taking 1 or 2 witnesses by video link as compared to everybody in the hearing room being on a video screen. So just to make a practical example, you should have 5 screens up in front of you. In the old days, 4 of us would be in one place and Viren would be in New York, and we would talk to him. Now we're all on the screen. So hopefully those slides will be with us in a tick. Thank you. So I'm sure these slides will be available afterwards. So for the first and second slides, that's just a little bit about our firm, King&Spalding. In short, we're an international disputes firm who do a wide range of cases internationally and locally, usually high value, usually very complex, usually involving several governing laws, and usually involving clients and witnesses from a number of jurisdictions. And as I'll show you in a moment, that's had a big impact for us on the nature of the virtual hearings that we've had to undertake. If I can go to the next slide, slide 3, that just gives you a little bit of an idea of us in terms of practice areas and global numbers. If we can go to slide 4. Now, slide 4 is very important because what slide 4 does is it represents the old way. Now, for those of you who like movies or courtroom dramas on TV, you'll all know this scene. For those of you who don't, this is one of the more famous movie scenes of a courtroom. And the reason I want to show you this is, for me, it captures all of the things that we're all used to when we are in a physical courtroom where everybody's in the same room. So I just want you to watch this, and then I'm going to pose some rhetorical questions for you.
Colonel.
You snotty little bastard.
Your Honor, I'd like to ask for a recess. I'd like an answer to the question, Judge.
The court will wait for an answer.
If Lieutenant Kendrick gave an order that Santiago wasn't to be touched, then why did he have to be transferred? Colonel, Lieutenant Kendrick ordered the code red, didn't he? Because that's what you told Lieutenant Kendrick to do. Object! And when it went bad, you cut these guys loose! Your Honor, you had markets inside a phony transfer. Your Honor, you doctored the logbook. Damn it, Captain! You coerced the doctor.
Consider yourself in contempt.
Colonel Jessup, did you order the code red?
You don't have to answer that question.
I'll answer the question.
You want answers? I think I'm entitled.
You want answers?
I want the truth!
You can't handle the truth!
All right, so very dramatic, very appealing, very Hollywood drama. But you'll see 3 or 4 things in that clip that in a physical hearing room are perfectly normal. The first and most obvious is you have 3 or 4 people talking at the same time. You have the witness yelling at the advocate who's cross-examining him. You have the lawyer who's defending the witness shouting both at the witness and at the lawyer who's attacking. And then you have the judge telling one lawyer he's in contempt, telling another lawyer to sit down, and telling the witness he doesn't have to answer the question. Imagination to realize that that just won't work in a virtual hearing. You can imagine now if Murat, Aycan, and Varen and I all started talking at the same time, it simply wouldn't work. So that's the first thing. The second thing is you can see the Tom Cruise character, the lawyer doing the examination. He's standing up, he's walking around, he's prowling around the courtroom. And as he does it, he's using fists, shakes, and a lot of demonstrative non-verbal communication. Again, by video, if I started prowling up and down this room, shaking my fist, I think you'd all be slightly worried about my sanity. The third thing is the drama with the witness. So you can see there's a lot of eye contact between the Jack Nicholson character and the Tom Cruise character, and they're staring at each other, and there's a lot of aggression around. Again, if I start staring at Murat now on this video screen, he's not going to think much of it, and he's not going to be intimidated in any way. So they're just 3 quick examples for you of the fundamental difference between doing a hearing physically and doing a hearing virtually. And as I'm going to come on to explain in a minute, what this has really meant for all lawyers who are courtroom lawyers, that a lot of the skills and a lot of the tactics, nuances, strategies that we've developed over the years as courtroom lawyers either no longer mean anything, or if they do, they arrive to us in a different way, and we've all had to adapt very quickly. So if we could, Matali, if we could please go to the next slide. Just give you a little bit of an overview of the cases in which we've had the experience. And the reason I want to show you this is because obviously a court hearing can mean many things. You can have an elaborate trial where you've got live witnesses and a number of languages involved and witnesses in several jurisdictions. all the way down to a very simple procedural hearing, which just involves 2 lawyers and a judge. And so the types of cases that we've had have informed us a lot about when virtual hearings can work and how they can work. And also, and I'm afraid to say there are a number of examples, hearings that just aren't appropriate for virtual hearings. So let me walk through these for you. So the first one was a large banking dispute before the Commercial Court in London. The Commercial Court in London is the premier business litigation court in England. And we had a trial in that court just at the beginning of the crisis. And that was very challenging because of the number of participants. There were a number of parties. There were 3 sets of legal teams. There was 1 factual witness located in Kazakhstan, and then there were 4 expert witnesses, 2 in Belgium, 1 in Kazakhstan, and 1 in Chicago. Now, that case was very driven by legal issues and submissions from the lawyers. There wasn't a great deal of forensic challenge to it, and there was no, although there's some allegations about whether a particular bank was rightly an agent and whether there should be a piercing of the corporate veil. It wasn't a fraud case. It didn't involve any serious allegations of dishonesty. So it was a relatively complex case, but relatively simple forensically, and we were able to do that. For me, based on my experience to date, that case, the Kazakhstan case, represents the limit of what you ought to be doing by way of virtual trial with multiple witnesses in multiple jurisdictions. The next case was an interesting example. It was an injunction case, also before the Commercial Court. And that, to me, was a good example of where virtual hearings work. It was filed shortly before the crisis, heard on the 7th of April, decision on the 24th of April. No live testimony, all submission. And that worked very well. The bundles were well organized. The parties were all very efficient. The judge handled it very well. And that, to me, was a good example where you can make virtual hearings work. Matali, if we move to the next slide, please. And just 2 more examples from the courts. We had a hearing relating to the challenge to an arbitrator in late April. And again, that was all legal submission. And there were no live witnesses, and the bundle of documents involved was pretty small, and it largely related to points of law. So that worked well. The important bit about that, though, and the area for real caution and another sort of red flag for us all to consider, was that hearing was in private because the judge felt it should be confidential and the names of the parties should be anonymized. So we had to be sure, given the technology we were using, that there was no leak, and the judge had to make some very significant and important directions at the commencement of the hearing to everybody on it to make sure that there was no recording of it, and so on and so forth. And here you'll appreciate that if you are in a physical hearing room and the door is shut, even locked, and the judge says to everybody in the room, no filming, that's likely to work because the judge can see what's going on and can control the space. Where, a bit like this video conference, there's a number of participants, it's a lot harder to police the idea that you can't take a video of it and use it elsewhere. The 4th case was an appeal heard on the 28th of April for the English Court of Appeal. So we had three appellate judges. And that, again, no live witnesses because it was an appeal, but it was complex and dense in terms of the factual material. And my humble observation was it is challenging when you've got 3 judges up on the screen and several advocates to keep track of everybody involved. And so, again, for me, appellate hearings and hearings involving 3 members and multiple advocates should only be heard virtually in exceptional circumstances, because I do think it is a challenge. In addition to those public cases, or the court cases, 3 of which were public and 1 private, we've also had a number of arbitration hearings of similar varieties, substantive hearings, procedural hearings, and interim relief. For me, the biggest distinguishing feature between the arbitrations and the courts has been, with the court obviously has duties and obligations because it's an arm of the state. and therefore has its own preferences in terms of systems to be used and how they're used. In arbitration, because it's a private process, it tends to much more be about the parties and what they can agree, and then present to the tribunal, this is the process that we intend to adopt. So in some ways, I think arbitration has been easier to adjust its approach and its procedure to this because it is a creature of agreement between the parties. Okay, so that should give you a picture of the types of cases we've had, and therefore the challenges and issues that we've come across. Natalia, if we could go to slide 7, please. Thank you. So here, what I've listed is just some of the first considerations, and I can't tell you how significant the challenge was for the Kazakh case. Imagine the lockdown in England started, I think, 48 hours before this hearing started, the full lockdown. The partial lockdown, or the sense that there was going to be a lockdown, had hit 3 or 4 days before. We were in court on an emergency hearing where my clients tried to move the court to adjourn the case. The court took the view fairly that justice needed to be served and we needed to get on. And we all got together, our team on our side, by way of course, video conference to talk about it. And it was daunting, the idea of trying to get about 50 people in multiple jurisdictions into the same place with a large lot of documents and coordinated in a short space of time was a real challenge. Thankfully, in that case, there was a lot of cooperation between the parties and a pretty strict court order that we had to do it. And that's how we got there. But these are the things that we juggled. So the first is obviously just the procedure. How's it going to work? And for this, you need to work out things like, who are the main speakers? What access do they need? What documents do they need around them? What electronic documents need to be available? Where's the judge going to be? What does he need to have? Where are the witnesses going to be? Where are they going to be located? Who's going to be with them? What documents will they have? How's everybody going to communicate with each other during this? Because unlike the traditional way where you hand notes or whisper to each other, all of those things are gone. How are you going to pick up the nuances from a hearing? And that's one of the obvious things that's different. So in a physical hearing room, you can see the judge, whether he's taking notes, whether he's raising his eyebrows at the arguments you're making. You can look at your opponents and see whether they're panicking or smirking and pick up how things are going. So how do you do that in a virtual hearing room? So those were sort of the procedural questions. In terms of platforms, there's been a lot of debate about this, and there's still more to go, because there's various options out there, and they all have their ups and their downs. A number of the hearings that we did were via Zoom, and I certainly found Zoom to be more user-friendly, more reliable in terms of content, both audio and visual. I found the gallery settings more appropriate in the sense that when I was speaking, I could just put the judge up and ignore everybody else. When I was listening to somebody else, I could have the judge up, but then 3 or 4 lawyers. So I think Zoom has some advantages. It also has some disadvantages in that certainly in England, the courts are suspicious and concerned about it because of the press reports regarding security issues. So the courts there prefer Skype for Business, which has security advantages. So that's an advantage of Skype for Business. I think one of the downsides is I personally don't find Skype for Business as reliable or as sophisticated a platform as Zoom. So just in a user experience, I would prefer Zoom over Skype for Business. And there are others. There's obviously WebEx, BlueJeans, Microsoft Teams, and we've experimented with those. And my own advice, my own view on this is that there's no golden rule. It's always going to depend on who the participants are, what kind of cooperation you've got, what kind of hardware everybody's using. And I think it's good to try a few and pick one that suits everybody given the various competing factors. Infrastructure is something near and dear to my heart that drives my colleagues crazy. Right now, I'm speaking to you on my firm computer with an HP Curve screen that's got a big microphone at the bottom and a webcam. I have used my MacBook, I have used my iPad Pro, and I've also used what's called a DX80, which is a Cisco purpose-built desktop video system. And again, they all have their advantages and disadvantages. The DX80 for me has delivered the best in terms of quality. The camera and the audio are superb, and it's sort of studio quality. The downside with the DX80 is it's a sophisticated bit of hardware that requires a certain level of Zoom or Skype or whatever software application you're using. And not a lot of people have that available. So it can only be used in certain circumstances. I find the iPad easiest to get on to a link, but then not as good in terms of performance once it's on. I find the iPad Pro is probably the best all-rounder. Sorry, not the iPad, the MacBook Pro is the best all-rounder. It's got the best camera and the best speaker, and it's the most versatile. And I think the work computer, which is a ThinkPad with all of this, is good, but it's 3 bits of kit that you've got to coordinate, and you're constantly checking to make sure how it works. So again, it depends on where you are, what you're doing, how often you're going to do it. But I certainly think for somebody who's been a little proud of the fact that I didn't know much about IT historically, I've completely changed my attitude, because these are now the tools of business. And I would encourage anybody who does hearings regularly now to be looking carefully at your hardware, because it does make a difference. All right, so Matal, if we could move to the next slide, please. Some other practical issues. The ensuring the trial is open to the public. That's the heading, but really it's a two-sided coin. There are cases where, like in England, the judge is obliged under existing law to ensure that the public are able to view court cases. And so in those cases, like this webinar, YouTube is an option, and there are various others. It is tricky though for two reasons. One, the judges have to rely upon the Coronavirus Act 2020, which was only recently passed, to give dispensation to the existing rules. That's the first thing. And the second thing is the court has to give important directions as to rebroadcasting and copyright, because what the English courts don't want, and I'm sure this is true of courts in a number of jurisdictions, is that public hearings being recorded and then disseminated elsewhere. So that's the challenges on that side of the coin. On the other side, there's the point that propped up during the A versus B and C case, in that if it's a private case, but it's being streamed to 20 participants, how do you ensure that there's no recording? And that, again, is a difficult one that raises a number of issues. And I think technology will advance on that. And unfortunately, someone will do it and will get caught, and there will be a significant penalty for it. And so we'll have deterrence in due course. So turning now to the other practical issues, and these really are probably the focus for me. I'll start with witnesses. One of the easiest things about a physical hearing room is that your witness enters the hearing room, and everything that he or she needs is there for them. And every concern and issue that you have with respect to that witness is there for you in the room. So you don't need to worry about the witness being coached, because you're sitting there looking at them, and so is the judge. And so all of the lawyers on their side can't be whispering them to them, or handing notes up, or putting signs up. Once they're in a room like we are all in rooms now by themselves with a camera that's just on them, it's a completely different story. And so for that, I think virtual hearings have a long way to go. There's been discussion about things like having a 360-degree camera that sort of goes around the whole room to see who's there. I'm skeptical as to whether that could deter or get rid of somebody who was determined. There's the idea of having a supervising lawyer in the room, social distancing, of course. There's various things that have been suggested, but that is, to me, a concern with virtual hearings. And I think it is something that will not arise in a straightforward, plain vanilla dispute where it's really just legal issues, but in any hard fought case where there's a lot of contention between the parties, allegations of fraud or serious allegations of dishonesty, or frankly, the parties just hate each other, I think that will become a real bugbear. And my preference is, on a serious case, I would not have a virtual hearing until such time as you can get witnesses in the room. Another practical issue that jumped on us very quickly and we learned about was how do we communicate with each other. So right now, if Murat thinks I'm being very boring and putting everybody to sleep, or he thinks I'm speaking too much, or he thinks that some of the audience need to hear from me on a different topic, if he was sitting next to me like he would in a hearing, he'd give me one of his notes or whisper in my ear. How do we do that? Well, we trialed a few things. One was emails. Problem with emails is if you have your inbox open and you've got emails coming in from colleagues on the trial team and emails coming in from other colleagues on other cases, it can be a distraction. We tried text messages and WhatsApp. Text messages weren't so good because you'd get 20 text messages from different colleagues. So far, what we've centered on is group chat on WhatsApp or Signal or something like that. That works reasonably well. I think there's two challenges to that. The first is, in the beginning, everybody was commenting on everything. And as a speaker, I was getting 450 WhatsApp messages about everything from the color of the walls on the judge's ceiling to really important points about the case. So we found we had to introduce some protocols. Don't send a message unless it's critical. If you send a message about a point, put the references in. So those are sort of the downsides. One of the upsides is a lot of my colleagues have terrible handwriting, and getting messages electronically on a screen where I could copy and paste them or drag and drop them onto my hearing notes and have them immediately there for me was very useful. The second thing is I've got a number of colleagues who are very aggressive about pulling my arm or punching me on the arm to tell me something. Of course, you don't have any of that anymore. So there's some upsides to the WhatsApp group. Another point is this: the testing. Now here we are on a webinar that we've all done plenty of. My colleagues and I are all experienced at this. We've had probably an hour and a half of testing for this webinar to make sure everything's coordinated, and touch wood, it'll stay like this. I can't emphasize enough how important testing is. And I don't think testing has taken less than 1.5, 2 hours for all of the hearings I have done. But I also have to confess, it has demonstrated all of the things that you can't think of that do and can go wrong. So the first test I did, I got on, had my computer up, everybody popped up, and then I suddenly realized that this computer was the computer I used for all my electronic files. So I got my iPad out. Another test I turned up, it was the day before the Kazakh hearing. I turned up with a t-shirt on, and all of the lawyers and the judge had suits and ties. And then I learned that tests are like hearings, and everybody turns up suited and booted, so you've got to do the same. So I think the tests are not to be underestimated and are not to be seen as something boring to get out of the way. I would really, it's a bit like testing an airplane. Take it as seriously as a real flight. The last thing I'll allude to is translation. I think that's an area where there is a lot of development to go. The translation that we've had in the cases that we've participated in has been a real challenge. And I think the reason for that is you've just got another layer of people through the chain. So you can imagine you ask a question, it gets translated by a translator in another room, it then gets answered by a witness and then translated back and then comes back to you. Often we do simultaneous translations in the sophisticated hearing rooms we've got, and people have got earphones and it works quite well. Sometimes we do sequential if we have to, but doing, I haven't seen, although the technology exists, simultaneous translation virtually I've only seen sequential, and it is slower and more cumbersome and more challenging than doing it live. And that changes the way you approach a witness. You have to ask shorter questions, you have to be more patient, and you have to cut your topics down, because if you do it the old way, it will take a long, long time. So we could just, Natalia, go to the last slide, please. So here, I just want to finish up with some basics. And I think these come back to the clip that I've showed you. And I just want you to imagine with each of these, the difference between a physical hearing room and a virtual. So connectivity is the key. In 2 of the hearings I've had, there have been problems with connectivity. Once my internet dropped out and I disappeared, and once one of the judges did. Now you can imagine an hour, you can't handle a truth scene if in the middle of Tom Cruise yelling at the witness, his internet broke. The moment would be lost, the witness would regain his composure, he'd come back and he'd give a clever answer. So connectivity is really important. I've got a backup, and I think if you're doing any serious amount of this, it's important to have two Wi-Fi systems on the go. Presentation of documents. Now, again, those of us who are used to using electronic bundles might think, oh, it's easy, I know how to use electronic bundles. The problem is, it's not just you. You may be very coherent with electronic bundles, but unless everybody else on the hearing is, it's not going to work. So I think you have to be prepared to use both physical and electronic so you can reference everybody. You need to have good colleagues ready to put things up on the screen like Natalia is doing for me now. And you need to be able to ad lib. So in a couple of cases I've really wanted to rely upon a document, but there's been a problem either with the judge finding it, the other side finding it, or the witness. And so you have to be prepared just to change and get on without the document, because there comes a point where trying to do it virtually is too clumsy. And I'll give you one last example on documents. You may recall from that movie, A Few Good Men, that the whole movie was about the question of whether this code red existed, which was an informal disciplinary system in the United States Marine Corps, where superior officers would have a junior officer disciplined for bad behavior by a code red, which basically means they'd get roughed up. And the whole film centers on whether there was such thing as a code red. So Kevin Bacon's character takes the United States Marine Corps manual and he shows it to one of the witnesses and he says, show me in here what a code red is. And the witness, of course, says, well, I can't find it. It's not in there. It's not defined. No one knows it. So Bacon turns around and says, wow, there can't be a code red if it's not in the manual. Tom Cruise snatches the manual, takes it to the witness and says, show me where in there it tells you where you get breakfast, lunch, and dinner. And the witness says, well, it's not in there. And he says, so while you've been in the Marines, you've never eaten breakfast, lunch, or dinner? And everybody, the jury, get the point that just because it's not in the manual means it doesn't exist. Again, that was a physical exchange of a document in a hearing room to great effect. That's not something, unfortunately, you'll be able to pull off virtually. All right, just 2 last points. Presentation of counsel, witness, and expert. Now, this is particularly hard for people like me who are getting old and technology is new to us. Things like the placement of the camera, lighting, background, all of that kind of thing. They're very different from a hearing room that you're in physically, but they are still important. And on one of the cases, I won't tell you which one, and I won't tell you who the lawyer was, all we saw of that lawyer for 3 days was a view like this, because his camera angle was bad and wasn't worked out. And that gets noticed because remember, on these hearings, you have clients, you have witnesses, you have colleagues. So it is definitely worth taking a bit of time and effort to adjust to your screen so you can see well, but people can also see you and they're not seeing your nose hair or your left earlobe or anything like that. I think the background and all of those things are obviously a preference, and it depends on what you're doing. But I have heard a story of somebody having a very inappropriate poster in their study that was beamed to the world on YouTube in a hearing. So you want to remove those little things like that. Lastly, use of the voice. Again, going back to the Few Good Men clip, you could see there that there was a real up and down, shouting, and then a really calm, did you order the code red? That, from my observation and from what I've seen, just doesn't work anymore in virtual hearings. It'll be a shame to some who are quite dramatic in their presentations, but the thing that is abundantly clear to me and my colleagues during this process is that the court is much more interested in being given simple answers to the complicated questions and nice bite-sized, digestible presentations of things that they can understand. And there is no doubt that looking at a screen and being on a screen is much more tiring than being in a physical courtroom. And what I have found is that if you are too long-winded or verbose or dramatic, you will lose the attention of a judge or arbitrator far more quickly than you would in normal occasions. So I definitely think honing advocacy skills to be more precise and succinct and focused in your presentation is very important. And last thing I would say is this: although we lose so much of the atmospheric in terms of the hearing room and the feel, and a lot of our skills are blunted as a result, one that is a lot more prevalent now is you get to have a much better look at the facial features of the person you're making submissions to. So in all of my cases, I've noticed that I've had a much better view of the judge, because usually you're 15, 20 meters away, whereas with a lot of the hearings, the judge is sort of like Murat is now. And Murat can't smile or twitch without me seeing him and knowing whether he's impressed or unimpressed. So I think that is quite helpful. But remember, the judge can see the same with you. So if you're one of those people who can't hide their frustration with the judge who doesn't get your point, look out. It's going to be more obvious than it used to be. So I will pause there and hand over to my colleagues. I hope we have some time at the end for questions, but thank you very much for your attention this afternoon.
Thank you very much, Tom. I'll be staying with you for a follow-up question, but I'd like to first apologize to the participants because I should have told them that there will be a Q&A session in the end. So my apologies. I know you're getting impatient, but I have just a quick follow-up question for Tom. Tom, how can you prepare your witness for a virtual hearing?
Yes, well, as you know, witness preparation varies from jurisdiction to jurisdiction depending on ethical rules. But what I have certainly seen is that quite often with witnesses, when you meet them face to face, you're able to relax them and say, this is just a process. All you have to focus on is telling the truth. Make sure you've read your documents. Make sure you understand where everything is. Don't worry so much about the bundles of legal authorities. Worry about the exhibits. That's a much more difficult task to undertake virtually if you can't be face to face with a witness. And it therefore takes more time. So I think spending more preemptive time with witnesses is very important. The second thing is, usually with witnesses, you don't have to tell them what to do other than to walk into a room, raise their right hand and sit down. I do think training them on video techniques, explaining some of the things that I've been through today, like background, where are you going to be? Is it going to be quiet? Will you have the documents available to you? What's your internet like? Is very, very important. And also explaining to them that, and on a couple of hearings I've seen this already, a witness is befuddled because they're not in a room and can look at people. They just sort of look around blankly and are a bit more lost and say things like, oh, can I ask my lawyer? Is that all right? So I think reminding them that although it's by video and it feels like it might be a FaceTime chat with their kids, it's in fact still a very formal environment and it's very serious, and they need to remember that. So I know they're fairly basic, but they're easy things to forget.
Thank you, Tom. Now I'd like to turn to Viren. Viren, this virus broke out in China in last December. In March, wars Health Organization declared this virus as pandemic. But before that and after, states took certain measures. Now we have been witnessing that the states are lifting or easing these measures somehow. But it doesn't mean that they will not take further precautions if things get worse in the future. So what obligations and rights do the parties have in an emergency like this?
Great, thank you for that introduction, Murat. And I think everybody will be pleased to know that I'm not speaking on virtual hearings, given that it would be a study in contrast with Mr. Sprange there with his great background and lighting and my rather sober surroundings here. But good morning from New York, and I know everyone's watching at different times of the day, so I hope you are all well. Murat, as you said, these are sort of crazy, chaotic times where everybody, including governments, they're trying to do the best with what they can in these somewhat unprecedented times, although people say, well, you know, back in 1918, we had the Spanish flu and the influenza, but still, for most of us, this feels like the first time around in a pandemic. And you're right that countries are doing a whole bunch of things right now. A lot of that has to do with the health sector. You know, they need ventilators, they need more hospital beds, they need to protect the supply chain of food. And then there's the question of the economy and how to deal with bailouts and the potential of a recession. You wake up in the morning and you read that Germany's entering into a recession. Today, the headlines in the New York Times said Japan goes into a recession for the first time since 2015. So definitely lots of different measures. Now, when I was preparing for this talk today, and you'll note that I don't have a PowerPoint, but I was trying to think about the audience here, because I know it's a range of people who have dialed in to watch us. And unlike a courtroom where we all have, you know, defined roles and we know who our opposing counsel is and we know who our witnesses are, this is an interesting experience in, you know, what do you know about investment treaty arbitration? So very quickly, I'm going to go into these treaties that protect investors investing in different countries and talk about the legal system. And then Aycan will go after me and sort of go into a little more detail about measures that countries have been taking and how they may affect the rights and obligations of investors and states. So basically, if you take a step back to the 1950s, when decolonization was, you know, fully underway at the worldwide, and these debates were taking place at the General Assembly, there was a sense that for countries, developing countries, to come out of colonization in particular, they needed to encourage the flow of capital from capital exporting countries, such as Germany and the United States, to capital importing countries, which tended to be at the time more developing countries. And so states began to negotiate these bilateral investment treaties with each other, depending on who they thought their trading partners were and how they wanted to encourage the flow of that capital. And so in the last 60 years or so, you've seen sort of what people call an explosion or a proliferation of these investment treaties, where statistics say that there are in excess of about 3,000 of them now, these bilateral investment treaties. There are also a number of multilateral investment treaties, such as the Energy Charter Treaty, under which a lot of arbitrations have been initiated. And these investment treaties and the potential for arbitrations under them were relatively unused in the 20th century. You know, there were some prominent cases and some that took place actually during civil war, such as the AAPL versus Sri Lanka case, when the investor said that certain actions taken, given the civil war going on in Sri Lanka, might have violated the full protection and security standard of the treaty. But for the most part, the cases were, you know, one-off cases. And in fact, there have been a lot of studies that have even questioned, do these bilateral investment treaties actually encourage the flow of capital? But investment treaty arbitration really took off, in my opinion, with the financial crisis that hit Argentina, you know, in which Argentina declared a state of emergency at the very end of the 20th century, and then leading up into 2001, 2002, 2003. It's interesting, if you go back to the wave of cases that hit Argentina during the time of their financial crisis, economic crisis, when Argentina had declared a state of emergency and had enacted a number of decrees and laws to address that emergency, how much there was this obsession and preoccupation with, can national crises constitute emergencies, the way that historically had been understood in international law as civil war situations or armed conflict situations. And most of those cases found that, yes, the answer was that an economic crisis could constitute an emergency. And we would have to think about how to analyze the rights of investors and the duties of states to respond to those emergencies, given their obligations under these investment treaties. So it's interesting that, sort of the cases took off in the first 5 to 10 years of this century, dealing with Argentina and its struggles with an economic crisis. Now, I feel a little bit like a school teacher when I say this, but even though I'm talking generally about bilateral investment treaties, when you're looking at the specific rights that an investor may have, and you're looking at the obligations that a state may have, you need to think about this in terms of the actual treaty that protects the investor. So you need to look at where is the investor investing from and what is the destination of that capital, and put together the patchwork of who is the investor that's being protected under which treaty. Because the terms of those treaties really will define the scope of the obligations owed to the investor. Now, of course, treaties don't exist in a vacuum, and public international law principles, in particular customary international law, will come into play, and we will discuss that. But really, your first guiding principle should be the terms of the treaties. What do they say? Now, for the most part, treaties tend to contain the following provisions. So I will just sort of discuss the main obligations and rights that investors have and that states must protect. The classic one is expropriation. And most people are familiar with expropriation. It usually tends to be built into their national constitutions, that there's a prohibition against a taking by the government without due process. That taking must be for the public interest. That it must be done with prompt, adequate, and effective compensation. And sometimes there used to be what I call the old school taking, which was essentially the army came up to your factory or your oil project and sort of took over the property. And then there's become now a more nuanced or complicated assessment of expropriation, which is regulatory taking, that the investor may still hold title to its investment, but its value may have been substantially deprived by virtue of a government's measure, or there's been a creeping expropriation, which over time has affected or effectuated an expropriation. So that's one provision that we'll come back to discuss. Another is fair and equitable treatment. Governments must treat investors who qualify for protections under their treaty fairly and equitably. Those are just 4 words, fair and equitable treatment, but they have spawned a whole host of case law and jurisprudence about what is the scope and content of that government duty to an investor. And that's broken down sometimes into sort of 2 ways of thinking. One is that the investor's legitimate expectations must be protected. And what does that mean, legitimate expectations? Typically, it means that the government has made some representation, some assurance to the investor that it will treat its investment in a particular way. So a classic example may be that the investor has negotiated a stabilization clause with the government, that the government will not enact taxes that exceed what is currently in existence at the time of the investment. And in this way, the government has worked with the investor to set legitimate expectations. But there are also other elements of the FET standard. It really goes to fair and equitable, which means that we're looking for the government's conduct to, was it inconsistent towards the investor? Was it not transparent? Was the government representing one thing and doing something else? Was the government acting in bad faith? So these are the kinds of considerations that may go into an FET or fair and equitable treatment analysis. Another provision is the full protection and security clause. I mentioned the AAPL versus Sri Lanka case, which is an example of physical full protection and security, that the government had an obligation to protect, in that case, the investor's shrimp farm from physical takeover and destruction by whatever forces were at play in Sri Lanka at the time. And full protection and security sort of has 2 elements as well. Historically, perhaps it had been understood to protect the physical investment and that there be security given to it by the government exercising some due diligence. In the late 1990s, as you had privatization of a lot of countries transitioning from communism, a number of cases came out and looked at full protection and security in the context of a legal stability. It was the government guaranteeing a legal stability that was being dismantled in a particular way, that security of the laws was not applying. And there's been some back and forth between the scope of full protection and security and fair and equitable treatment, just as there's been some push and pull with the scope of fair and equitable treatment and regulatory expropriation, for example. So these provisions have evolved over time in terms of how they've been interpreted, but those are some of the classic provisions. A couple more provisions that may come into effect during times of a pandemic. Some treaties protect the transfer of funds by an investor, that the investor should be able to repatriate its investment and proceeds out of the country back to its own host state. And so sometimes now we're reading about measures in which countries, especially as they're considering or are concerned about an economic crisis, may impose capital controls or export restrictions. So in those treaties that contain transfer of funds or export, free flow of export and import provisions, you should perhaps look at that in terms of the government measure. And then you should also think about national treatment and most favored nation clauses. These provisions come out of a long history of customary international law in which there was a focus on protecting the property of aliens and the treatment of aliens from being done in a discriminatory manner by governments vis-a-vis its own nationals, or even vis-a-vis third nationals with which the government may have negotiated different standards of treatment. Those provisions are also familiar to those who deal with trade law, as they're very much built into the GATT system. And many treaties contain protections of most favored nation and national treatment. And I think during these times when you're hearing a lot of discussion by governments about protecting the domestic industry or trying to provide a bailout to a specific domestic company, these concerns about MFN and national treatment might come into play. So I've laid out some provisions that investors may generally be on the lookout for if they're facing measures by governments that impact their investments in the state of investment. But I would be remiss if I didn't talk about the point of view from the government. So of course, an investor needs to prove the elements of its claims to win on those merits, but there are also defenses that are available to governments. And I mentioned earlier that treaties are lex specialis, but that they don't exclude typically, unless they expressly do so, customary international law principles applying. That sort of works its way in either through provisions in the treaty that will actually make reference to general principles of international law. It may also make its way into the treaty through interpretation under the Vienna Convention. And I'm thinking here about Article 31, subprovision 3C, which also sometimes is used to incorporate customary international law into the interpretation of a treaty. And now in a seminal study that was done by the International Law Commission, previously by Special Rapporteur Ago, and then taken over by James Crawford, there has been a study come out with the responsibility of states for internationally wrongful acts that was submitted earlier in the century, in the early years of the century. And there's a section of those ILC articles that talks about defenses by states that may preclude wrongfulness, where otherwise they would be in breach of an internationally wrongful obligation. And I don't want to go into most of those defenses that may not really be relevant in the investment treaty context. Things like classic self-defense, which are under Article 2, Subprovision 4 of the UN Charter and Article 51 of the UN Charter. Those are less likely to be at play in an investment treaty case. Or even, provisions dealing with distress, which typically are where, an airplane has to fly into another country's airspace because of, let's say, a storm that's taken place. And so it is a breach of the obligations if it hasn't secured consent to be in that airspace, but the doctrine of distress may excuse that wrongfulness. What I'd really like to focus on are just two defenses. One is force majeure, and the other is necessity. And I know that Aichan is going to go into those defenses as well, so I won't spend too much time with them. I'll make some observations about them though, which is that as those standards, as those defenses have been codified in the ILC articles, you really should take a look at the way in which the defenses have been spelled out, because the conditions are quite difficult for states to satisfy successfully, to be honest with you. And those conditions have to be satisfied cumulatively. All of those conditions must be met before the state can successfully claim that defense. So for example, with regards to force majeure, which is spelled out in Article 23 of the ILC articles, there are 3 conditions that a state must satisfy. It includes that the act must have been brought about by an irresistible force or an unforeseen event that was beyond the state's control, and that makes it materially impossible for the state to perform the obligation. And there are also some other caveats that the state can't benefit from force majeure if it contributed to those events, or if it had assumed the risk of that situation occurring, because then it wouldn't be unforeseen. So, you know, you may have an investment contract with a state that actually spells out the force majeure provision. Just as you have that in commercial contracts, you oftentimes see the force majeure provisions. And in those situations, you would read the force majeure clause in accordance with its terms. But if you don't have a force majeure situation and you're under a treaty, you may see force majeure being asserted as a defense by a state as part of customary international law. And similarly with Article 25 of the ILC articles, which deals with necessity, there is quite a high standard there for the provision to be satisfied. And what I'll just say and take a step back here is, you know, Argentina, when it was dealing with that whole wave of cases that were brought against Argentina, it asserted that defense of necessity in its cases. And oftentimes there was this discussion of, do we look at necessity as framed under any provision of the treaty, the specific BIT between Argentina and one of its trading partners, or do we look at Article 25 of the ILC articles to figure out how to interpret necessity? And I think when you look at the cases in sort of at a high level, when you look at LG&E, or you look at SEMPRA, you look at Enron, you look at CMS, and the way that those annulment committees and the tribunals grappled with it, you can come up with the following observations. That one, there's a recognition pretty clearly that Article 25 and necessity forms part of customary international law. That in the absence of any provision, such as dealing with necessity or dealing with essential security clauses, that the state may assert that defense of necessity as part of customary international law. But in those circumstances, it will be held to the high standard of whether it can successfully show that the elements of that defense have been met. Some treaties contain provisions on necessity that say that in certain circumstances of, you know, public order or emergency, that a state may take actions that are necessary to protect its interests. And those cases against Argentina routinely have found that an economic crisis may trigger necessity. And then there's a focus on the plain language of that necessity or essential security provision to make sure that do the requirements apply or not. I'm going to sort of wrap up by saying that, you know, we have seen investment treaty cases come out of emergencies and crises before. And I focused quite a bit on Argentina and the economic crisis, but the same thing happened, although maybe to a more limited extent, following Arab Spring that took place in 2011, and then in the years thereafter, resulting in revolutions in certain Middle Eastern countries. And that too gave rise to questions about necessity and decisions made by those Middle Eastern countries to protect or take measures to protect their economy. There were predictions about a lot of cases coming out of the financial crisis in 2008. And there were questions about the extent to which, you know, bailout money here in the US under the Troubled Assets Relief Program would trigger perhaps a treaty breach, because was it protecting the domestic industry? There are questions about sovereign debt and forced restructuring. We saw some cases brought against Greece because of how it treated its financial crisis, and concerns about discriminatory treatment and nationality of investors. So all of this is to say that you've got to look at the measure. You have to tie it up to the provision in the treaty that could give rise to a breach. You have to see what defenses the state may have. And you have to bear in mind that we're dealing with public health here, in which there is a lot of sympathy at this time for governments as they're grappling with all these issues. So that's my overview of the things to think about investment treaties and COVID and an emergency.
Thank you, Ren. I'll ask a follow-up question to you as well. apologizing, Aycan. This will be a general question, actually. You touch upon the issue to some extent, but because of its importance, I'll ask it anyway. What points should a state consider in terms of foreign investment when taking a measure?
You know, Murad, I think that what generally states should do at a high level is to consider whether the measure is necessary, to consider whether it needs to enact emergency legislation or declare a state of emergency that may give broader powers to the executive or to the legislative branch with regards to enacting measures to deal with that emergency, that it should certainly follow any provisions in its national law and legislation regarding the effectuation and the enactment of decrees pursuant to that emergency declaration. It should consider very carefully the issue of discriminatory treatment about the foreign investor versus nationals or most favored nation nationals. And then it should look at whether in its general BITs, it has provisions dealing with necessity, it has provisions dealing with essential security clauses that cover public health emergencies or declarations of safety of public order. Those are the sort of things it needs to think about and to make sure that it has a very documented process as it passes those measures.
Thank you. Now I'd like to turn to Aycan. Aycan, Viren explained very well the obligations and rights of the parties. Can you please give us some specific examples of these measures taken and potential disputes?
Thank you very much, Murat Bey. First of all, I would like to thank again Tom and Viren for their very useful and enlightening speech. So I can start my speech with my PowerPoint. Now I will continue with specific examples of the state measures in response to COVID-19 pandemic, and then we'll make some general remarks on circumstances precluding wrongfulness of an act of state in response to COVID-19 pandemic. As Viren explained this in a detailed manner, I will just make some general remarks, and then I will end my speech with a case study. So, as you know, our social and business life are widely affected by the measures implemented by the states with respect to COVID-19 pandemic. These measures are not limited to, but including application of quarantine for certain cities and regions, restrictions on domestic and international travels, curfew applications in some countries. This may include certain cities or whole country, closure of business and shopping centers, and seizement of the industrial manufacturing. But of course, there are some other more aggressive and effective serious measures taken by some states. For instance, Spain has nationalized all private hospitals in the country. On 16th of March, the Spanish Ministry of Health has declared that the government is putting all private hospitals in the country under state control indefinitely. So here the critical thing is they took this decision for an indefinite period. Another example comes from France. France has seized millions of masks intended to be sent to Italy and Spain by a Sweden health company. Similarly, Germany has banned the export of masks and gloves. Although this measure was limited for a specific period for between 4 March and 19 March 2020, this should be considered again a serious measure for a foreign investor in Germany who is dealing with the exportation of masks and gloves to other countries. And the last example comes from Peru. Peru has issued an emergency decree suspending the collection of the fees, toll fees, on the country's road network. And we see from GAR News that even Peruvian officials have warned that a proposed emergency measure suspending the collection of toll fees on the country's road network in response to COVID-19 pandemic may result in multiple exit claims against the state. So before going to the case study, I just would like to make some general remarks on circumstances precluding wrongfulness of an act of state in response to COVID-19 pandemic. So there are, in fact, main two legal grounds that states may rely on to argue that they shouldn't be held liable for their measures in response to COVID-19 pandemic. The first measure, the first ground is the exceptions in the bilateral investment treaties with respect to the protection of health or public security. The second ground, as Viren already explained in a detailed manner, the provisions under the ILC draft articles. These provisions are force majeure, distress, and necessity. So distress also can be considered as a reason, but of course, I agree with Viren that the force majeure and necessity may be more suitable for the states for this specific issue. So I just would like to make some explanations about the first legal ground, the exceptions in the bilateral investment treaties due to the protection of public health or public security. So it may be possible that the acts of state, in order to ensure the protection of health or natural life or public security, can be considered as an exception in a bilateral investment treaty. So in that case, actions of the state as to the protection of health may not be considered as a violation of its investment protection obligations arising from the relevant bilateral investment treaty. So here I want to give an example for this exception. Under the bilateral investment treaty between Turkey and Azerbaijan, in Article 5, it is explicitly stated that nothing in this agreement shall be construed to prevent a contracting party from adopting, maintaining, or enforcing any non-discriminatory legal measures designed and applied for the protection of human, animal, or plant life, or health, or the environment. So in a possible case in the future, if a respondent state, if in this case there is a bilateral investment treaty provision which contains such an exception, then the respondent state may rely on this exception, this provision, and argue that even if its action in response to COVID-19 pandemic may constitute a violation of its investment protection obligation, it shouldn't be held liable for such action because of this exception. Of course, it should be considered by the tribunal based on the circumstances of this case. The second ground, as we discussed, as Viren explained in a detailed manner, the provisions under the ILC draft articles. These are force majeure, distress, and necessity. So just before starting the case study, I would like to mention the factual grounds to invoke force majeure, distress, and necessity defense under ILC draft articles. So first, there should be an unforeseen situation. Second, this unforeseen situation should be irresistible and beyond the control of the state. Third, there shouldn't be a fault or contribution of the state in occurrence of this situation. Fourth, there should be a grave and imminent peril against the interest of the state and public. Fifth, there shouldn't be another more appropriate act or measure which can be applied by the state. Sixth, performance of its international obligation should materially become impossible for the state in question. Seventh, the act in question should not create a comparable or greater peril for the state and its nationals. And eighth, the act in question should not seriously impair an essential interest of the state or states towards which the obligation exists, or the international community as a whole. And finally, the international obligation in question should not exclude the possibility of invoking necessity. So, for the case study, I took the example of nationalization of private hospitals, the example of Spain. So if we assume that a foreign investor who owns a private hospital in Spain faces with this kind of a measure, it may consider to file an investment arbitration case against Spain before ICSID or any other investment arbitration forum. So in case of such a case, how should the investment arbitration tribunal approach to this case? And what kind of issues should be dealt with by this tribunal? So first of all, we are of the opinion that, first of all, the tribunal should look at the bilateral investment treaty, as Viren mentioned, here between Spain and the home state of the foreign investor, to see whether if there is any exception in this bilateral investment treaty with respect to the protection of public health, such as Article 5 of Turkey-Azerbaijan BIT. So if there is such an exception in this bilateral investment treaty, then Spain may argue that even if its action, namely nationalization of the private hospital, may constitute a violation of its investment protection obligations under the bilateral investment treaty, it shouldn't be held liable for this action because of this exception prescribed under the relevant bilateral investment treaty. The second issue is, does the BIT exclude the invocation of necessity defense? In some cases, bilateral investment treaties may exclude the invocation of necessity defense. So here, the tribunal should look again this BIT to see whether if there is any exclusion for the invocation of necessity defense. If there is this provision excluding the invocation of necessity defense, then Spain most probably may not be able to rely on the necessity defense. But of course, it doesn't mean that Spain cannot rely on force majeure argument or distress argument, which are also prescribed under the ILC draft articles. So you see here 11 items. And the first 3 items are the possible claims, arguments, which can be asserted by the investor in such a case. Violation of fair and equitable treatment obligation, violation of full protection and security obligation, and the expropriation. So under the normal circumstances, an investment tribunal may conclude that nationalization of a private hospital by Spain should amount to violation of FAT obligation, full protection and security obligation, and expropriation. However, in our case, when we consider COVID-19 pandemic, then if Spain also is able to successfully rely on force majeure, necessity, and distress arguments, then it may be possible for the tribunal to conclude that even if Spain's action may amount to violation of FAT obligation, full protection and security obligation, or non-expropriation obligation, Spain should not be held liable for such action due to the necessity, force majeure, or distress reasons. So in order to understand this matter, we need to look at each item together to be sure whether if Spain can successfully rely on these provisions. The first thing is item 4, there should be an unforeseen situation. So the tribunal, to understand this issue, should ask to the parties whether if COVID-19 pandemic should be considered as an unforeseen situation. And the answer should be obviously yes. COVID-19 pandemic should be an unforeseen situation for Spain. Item 5, this unforeseen situation should be irresistible and beyond the control of the state. So here, we should ask this question: is COVID-19 pandemic irresistible and beyond the control of Spain? The answer, I think, should be obviously yes. This was irresistible and beyond the control of Spain. Item 6, there shouldn't be a fault or contribution of the state in occurrence of this situation. So here the tribunal should ask this question: was there a fault or contribution of Spain in occurrence of COVID-19 pandemic? So here we can also answer this question as no. To the best of our knowledge, Spain has neither fault or nor contribution in occurrence of COVID-19 pandemic. And the item 7, there should be a grave and imminent peril against the interest of the state and public. So here the question is, was there a grave and imminent peril against the interest of Spain and its nationals? The answer should obviously be yes. As you know, Spain is one of the most adversely affected countries in the world from COVID-19 pandemic. That's why we should accept that this was a grave and imminent peril against Spain. Item 8, there shouldn't be another more appropriate act or measure which can be applied by the state. So this is a tough question, and also Spain may have difficulties to answer this question. Here, the question which should be answered is, was there another appropriate act or measure which can be applied by Spain? This is also related to the proportionality principle prescribed under international law. So here, claimants may strongly argue that there should have been another appropriate act or measure instead of direct nationalization of the private hospitals in the country, such as strong coordination between state health institutions of Spain and these private hospitals. Therefore, in order to win its distress and necessity arguments, Spain shall need to prove that there wasn't any alternative way other than nationalizing these private hospitals due to these circumstances in struggling with COVID-19 pandemic. The other issue is item 9. Performance of its international obligations should materially become impossible for the state in question. So here we need to ask this question: did the performance of its international obligation become impossible for Spain? So here again, claimant can strongly argue that Spain was able to perform its international obligation not to expropriate its investment, the foreign investors' investment, even under the situation of COVID-19 pandemic. So this is also a tough question and tough argument for Spain. And to win this argument, Spain should in any case prove that there was no other option rather than nationalizing the private hospitals in the country. Therefore, as long as Spain can prove this, it can be also possible for Spain to prove that it became impossible for itself to perform its international obligation, namely not to expropriate the private hospital in Spain, in the country. And the item 10, the issue is the act in question should not create a comparable or greater peril. So here we need to ask this question: did Spain's action in question create a comparable or greater peril? And the answer should be no, because Spain's purpose was to give more effective, faster, and free health services by taking the control of all hospitals in the country. So this action in principle should not create a comparable or greater peril for state or its nationals. And the last issue is the act in question should not seriously impair an essential interest of the state or states towards which the obligation exists, or of the international community as a whole. So here, the tribunal should ask this question to the parties: did Spain's action in question seriously impair an essential interest of Spain or the foreign investor towards which the obligations exist, or of the international community as a whole? So for the short term, it can be argued that Spain's action should not seriously impair an essential interest of the state. Contrarily, this action can be considered critical and necessary for the protection of public health in response to COVID-19 pandemic. However, it's not the case for the foreign investor who have lost the control of his investment in Spain. So that's why when we consider the long term, due to its international obligations, such as protection of foreign investments, Spain may face with serious and significant compensation claims. And this may seriously impair the essential financial interest of the state. So therefore, if these nationalized private hospitals are given back to the foreign investors within a reasonable period of time, then Spain can also win this necessity defense argument. Otherwise, Spain can be held liable for this action and may face with serious compensation amounts that can be awarded by the investment arbitration tribunals. So this is the end of my speech, and thanks for listening to me. I give the floor to Murat Bey.
Thank you very much, Aycan. What I'm going to do is ask the questions. I have received a couple of questions for you guys. There are some questions on virtual hearings, so Tom, feel free to start first, but other speakers' comments will be welcome as well. And other questions, I'll ask the group, feel free to jump in. My first question, Tom, you actually touch upon this issue in your speech, in your presentation. You know, when for the lay witness to testify at home could be very challenging. The physical environment might not be suitable to testify. There may be small children around in a home. This is well for everyone actually, but it's also true for witnesses. And there are certain technologies now introduced, so all parties can see the room in which the lay witness is testifying 360 degrees, cameras, everything. And would you be comfortable, even in this environment, if you see 360 degrees in the room? And would you choose virtual hearings?
I mean, I think it's a good question. I think that the reality is when the crisis is over and we're all able to get back in the room together, I don't think anyone will be suggesting that virtual hearings are the way to go and we shouldn't be doing physical hearings. And one of the reasons is exactly what you said. I don't think any of us have the luxury of having a lot of space that's super quiet and immune to all of the normal sounds of everyday life, like dogs, children, lawnmowers outside, things like that. I do think the longer this goes on and the more that becomes a challenge, there will be, for example, if you look at the IDRC in London and the IAC and the similar institutions in Canada and New York, in Paris, those are hearing centers that have hosted physical hearings for a long time. What they're now doing is you can put witnesses and other people in the center, safely, socially distanced, to give evidence and present. So I think, and the other alternative is law firms, and that gives the added advantage of being able to have a lawyer, an independent lawyer, supervise. So I think there are already, and there will continue to be challenges with witnesses at home who won't be able to get a quiet environment, or who won't want a 360-degree camera going around their room. I'm quite happy for you to see the back of my room, but I don't want you to see the front of it because it's piled up with papers and everything. So yeah, it's a common challenge. There are already some solutions, but other than tidying up, moving things around, telling people to shut up, I don't think there's much we can do about it as yet. But I do think those other solutions will become more prevalent.
Thank you. Any comments from other speakers? Red?
Nothing from me.
Okay. Thank you. Some institutions issued some guidelines to mitigate the effects of COVID-19. Did you find these guidelines helpful, first of all? And
Yeah.
In general, how did COVID-19 affect your business, your practice?
So in answer to the first question, there's obviously the SOL guidelines, which have been around for a while, it came into play before the crisis. And since then, I mean, you only have to go on LinkedIn or to any of the institutes, LCA, ICC, and there's lots of guidance. So I think that's helpful and that's good. I think the guidance is a good starting point, and I think it's a good checklist of things that you need to consider. I think it's a good roadmap of a process you need to put in place. I will say this though, they remain general guidelines, and I think every case is bespoke in its own way. The second thing is nothing substitutes practical experience of actually doing things. Just because you have
I think so. We couldn't hear you well for a couple of sentences. Sorry about that. It might be internet. Would you mind repeating the last couple of sentences for us? In the meantime, if we're feel free to jump in if you have any.
I'll just briefly say that, you know, I have tremendous gratitude to the institutions, which really are trying to come up with these generalized protocols that will assist arbitrators in issuing their pre-hearing procedural orders, and that will assist the parties in figuring out what they need to do in terms of technology and security precautions. But I think the line that I did hear from Tom before it got fuzzy, that really resonates with me, is you do need to think about the specifics of your hearing, you know, in terms of what do you need to achieve for your client in terms of the opening, the closing, where your counsel is, where your witnesses are, what do you need to achieve from those cross-examinations, how many experts do you have, where are they located, what do those bundles look like, how big is the case record, do you need translation and simultaneous interpretation, do you need live note in multiple languages? You have to use those checklists to create your own specialized guidelines.
Thank you. This is also important for the clients. How would you compare virtual hearings in terms of cost? Tom?
My sense is that, I'll take it because Tom has a questioning look on his face, so I don't know if he's having some internet trouble. But what I will say is that, you know, a lot of what Tom said, that you need to prepare in advance significantly, that really does apply here, because unlike in a physical hearing where you've got your team together and you can do that whispering and can you find me that C document or that R document, or there's that collaboration, here you do need to think in advance of how am I going to get my cross-examination across effectively with limited time, with limited patience, frankly, from people. So you need to do the prep on what could I cover and then what should I really focus on. So a lot of, I think the costs, Murad, in terms of preparation, it'll be more intensified preparation. There may be some logistical costs that are saved by not traveling and so forth, and hotels and things like that. But in terms of the lawyer hours and preparation hours, I think those will remain significant.
Murat, sorry about that. It was a good example. It's a good example of what can go wrong. Just one thing I wanted to pick up on. Vera may have covered it, but the guidelines. If I gave you the guidelines for how to jump out of a plane, you could read them in half an hour. That doesn't mean you'd be ready to jump out of a plane. So I think it's the same. There's a lot that can go wrong with virtual hearings. So I wouldn't, the guidelines are a starting point, but that's it. And on the question about change in practice, I mean, I think Varen and others, I'm sure Aichan has the same view. We've just been busier, and for the reasons that Varen's articulated, it's got the preparation's got tougher. And the other thing is, because we're all in lockdown, everybody knows we're not on planes, we're not out doing other things. So there's an expectation that you're more available. And the other thing is, organizing a hearing now is much easier. We've got an interim relief thing that's just been filed, and we've got a hearing date very quickly because all we have to do is get on a video. So, you know, I know everybody thinks lawyers do better in crisis, but I think this is going to lead to an increased efficiency, which will, whenever you get increases in efficiency in the law, it tends to mean people get busier. So that's the experience so far.
Yeah. Do you have anything to add on cost, Tom?
I agree with Varen. Yeah, I agree with Varen. I think the level of preparation needs to be more intense, because you need to get this in place. You need to have tests. As Varen says, the lead advocate needs to know all of the documents, not some of them, because he doesn't have, well, he or she doesn't have colleagues around. You know, I tend to work largely with the hard copy bundle, and then as I get close to the hearing, I start morphing to the electronic bundle. I think now you have to be as fluent in both so you can help whoever's into them. So yeah, I agree with Varen. I think it's certainly, to begin with, it's going to be more expensive. I think if we're still doing this in 6 months, I think the systems will have become standardized, and our skills will have adjusted, and it may start coming down. But right now, it's definitely, it's a big challenge on costs. And the last thing I'd say on that is, a hearing that would have taken you 5 or 6 days before will now take you 2 or 3 days longer, just because of the video feedback slowing down. Yeah, so it's a real challenge.
Aichan, do you have any comments on cost? I think Viren and Tom explained pretty well, but feel free to jump in.
Thank you, Murat Bey. I agree with Viren and Tom. Although it seems that it may not be very costly compared to the physical hearings, but this is very right determination that there should be lots of things in terms of technical matters, and also sharing the witness bundles with witnesses. And, you know, comparing with the physical hearings, there are lots of things that we need to do to make a successful virtual hearings. That's why it may even be costly than the physical hearings.
Thank you. This is more of a theoretical question, actually. Can the states get together and create an international law as to COVID-19? And would that be beneficial for the states and the practitioners?
That's a difficult question. So Aichan, do you want to go first so I can hear what you have to say and build on to that?
You might guess. You can go first.
Well, Murat, that's an interesting question. I mean, you know, you have the WHO that has declared this to be a pandemic and an emergency. Unlike some of the other crises before, the Argentina crisis in particular, which was, I mean, other countries went through the financial crisis, but a lot of the focus was on what Argentina itself was doing. You know, when you look at the Arab Spring crisis, the cases that really looked at the situation in Libya, which it had its own period of civil unrest. So my sense is that this is going to be an interesting pandemic in terms of how to measure the government responses in terms of obligations under a BIT, because countries all over the world have been affected. Countries all over the world are applying you know, a range of measures, some of which overlap with each other. Countries all over the world are coordinating with each other in terms of knowledge sharing, the vaccine development, but also in terms of how to address that a recession that impacts Germany will impact Japan, will impact the United States, will impact Turkey, and so forth. And so what I think you're going to see, you know, when I looked at cases coming out of previous emergencies, there were expert reports submitted on the industry, on the kinds of measures governments could take, what caused something or did not cause it. And I think here you're going to see a much more comparative development and assessment of the responses of governments, and whether that creates a kind of localized or no, specialized jurisprudence to deal with a public health emergency in the context of an investment treaty. I think the jurisprudence will look at the range of measures overall.
Thank you. Any comments?
Please, Tom.
The only thing I was going to add is this, that I think it's a really nice idea. But one thing I've noticed from crisis, whether it's financial or let's use ICANN's label, force majeure, is that states very quickly start worrying about themselves and their domestic commitments and the executive's popularity and all of that kind of thing. And so the idea of helping other sovereigns quickly becomes, once the bill for this crisis starts to bite in all these jurisdictions, I think they'll become a lot more cynical about helping each other. And the other thing is, if you look simply at whether the EU can agree over whether there should be intra-EU bits or not, and the drama that we've had over that for the last 4 years that continues, what's the prospect of having either EU or even intra-nation treaties about COVID? I just think that I think it'd be easier for all of us to open a court on Mars and practice law there than that to happen personally. But I've been wrong before.
I will add one thing, Murat, which is you really also have to see where these emergencies end in the different countries. Because one of the issues is, what are the government measures during the period of the emergency? And then there's a question of measures that were taken that were not related to this public health emergency and which may later be put into place to effectuate a government's domestic agenda. So in a lot of the cases that analyze emergencies and looking at the necessity defense, for example, there actually is a focus by the tribunals to demarcate when does this start and when does this end? And what measures thereafter were not directly related to the specific emergency, and to hold the government liable for those measures. So I think that's one aspect that needs to be considered too. Emergency and what's related to the emergency, and when does that emergency end and the unlawful measures begin.
In addition to Viren's and Tom's thoughts, also I would like to say that here the period of time of the measure also should be very important. As we gave examples, for instance, Spain decided to nationalize the private hospitals for an indefinite period. This is an open-ending measure, so this could be considered seriously in terms of the rights of foreign investors. On the other hand, Germany, for instance, has banned the exportation of gloves and masks just for 2 weeks. So this should be considered within its factual circumstances. So when it comes to preparation of an international law, I think we should look at 2 important things. The first thing is the period, the timing of the effects of COVID-19 pandemic. We will see how long it will continue. And the second is the measures that the states are applying, the timing of the measures. So if we understand that both COVID pandemic and the measures will continue for a long time, then it may be important to think about what we can do, what states can do. For instance, they may come together to review again their bilateral investment treaties, to make some revisions in the bilateral investment treaties, to put some exceptions, like the Article 5 of Turkey-Azerbaijan BIT, or as Viren said, we may rely on the jurisprudence that we can see in the near future based on the investment arbitration tribunal's awards with respect to the state measures arising from COVID-19 pandemic.
Thank you, John. I have only 2 questions left. I don't want to take too much time of our participants and yours also, of course. Is there any time period in which the investor should notify the state of the effects of COVID-19?
That's a very tactical decision to be making, even in times of not an emergency or not a pandemic, because obviously when you file a notice of dispute under a treaty, you trigger sort of the dispute settlement system with the government. which then might require a period of 6 months or up to a year to try to negotiate that settlement. We have seen examples actually of trigger letters being filed during the pandemic, where the governments have simply written back saying we need to extend the period of negotiating under the treaty by a certain number of months to account for the fact that government workers are working from home, they have restricted access to the documents and the archive of materials. So I think that's one tactical question, but really it'll turn on the extent to which the investor is facing a breach that impacts its investment in a particular way. If the game is up, quote unquote, and your investment has been nationalized, or the government measure is so serious that your business cannot go forward, then you may have less incentive to wait and you go ahead and file that dispute. If on the other hand, you're watching measures take place over a period of time and you can envision that they're going to breach your treaty rights in some way, but you're not yet hard hit, you may want to take some time just to see how this all plays out. So I think it really depends more on the facts and circumstances of the government measures, the timing of them, and the impact that it has on your investment.
Thank you. Anything to add from?
I agree with Brian. I have nothing to add.
Okay, thank you. The last question then. Would the level of development matter in terms of measures taken in the eyes of the tribunal?
I'm happy to go first, but I'm conscious that I'm always the one speaking first, so I'm happy to defer to my colleagues.
I always let Viren go first.
And then you can do one better than me, Tom. So I'll be the guinea pig. The answer, I think, Murad, is going to be yes. That tribunals will look at a country's developing country status, its GDP, its economy, the degree to which it was hit by COVID, its public health system, including the insurance sector and hospitals, and it will take all of that into account when trying to decide whether a government's measures breached a treaty obligation. And in some ways, the treaty invites that, right? I mean, if you look at the fair and equitable treatment provision, when you're looking at an investor's legitimate expectations, you do see tribunals that sort of draw distinctions between certain countries and other countries when trying to say that this is something that you could have factored in when making the investment. And I think as a practical matter, when you look at all the cases involving Argentina, but also involving Middle Eastern countries, or involving Greece, frankly, after the Greek financial crisis and the bailouts there, there was a real focus on the facts and circumstances of the country as a whole, of the sector that was being affected, and a really searching look as to why the government did what it did. So development matters.
Good. Tom?
That was perfect, and I couldn't possibly add to it.
Great. Do you have, if you have anything to say to our participants, please feel free to say so. Otherwise, I'll close the webinar.
Thank you very much for your kind attention this afternoon, and maybe we'll see you on a virtual hearing of some sort in the not too distant future.
You're on which?
See, I went the entire thing without screwing up in that way, and in the last moment, I forgot to go off mute. I just want to reiterate my thanks to you, Murad, for organizing, and to those of you who've dialed in. We appreciate your interest.
Also, I would like to thank to Tom, Viren, and to you, Murad Bey, for moderating this webinar. And thanks to all participants for joining and listening to us.
Then I'd like to thank the speakers for their very well prepared presentations and their time. And I'd like to also thank our participants. Please stay safe and well.
Thank you.